Hello and welcome to this presentation on zombie litigation, um, how to survive the claims that simply will not die. So what do I mean by zombie litigation? Well, it's essentially those cases which break out of the statutory stays on litigation in insolvency. So I'll be looking a bit at why and how cases like that break the stay and are allowed to continue despite the liquidation administration or whatever sort of procedure it is. Now, most of those cases come under the category of claims brought under the Third Parties Rights Against Insurers Act 2010. So I'll be looking a little bit at that piece of legislation and how it works in the context of claims like this. I'll also be looking at Atlantic Computers, which, although in its narrow sense is a case about repossessing hired goods in administration, nevertheless does establish some general principles that I think are very useful, very important for all types of insolvency procedure and many types of claim. I'll be looking at the court rules, particularly CPR 31, which contains some useful and important rules about costs that can help you. And at the end, I'll be trying to pick up some practical points from all of this about how to deal with the zombie apocalypse, cases where you're at risk of being swamped by litigation that's being brought after your appointment. And the sort of cases which seem to be most at risk of being affected by a zombie apocalypse are perhaps financial services companies, where you may have a series of mis-selling or negligence claims that could be brought by a large number of disaffected customers. So let's look at what sort of circumstances can trigger what I'm calling zombie litigation. And what I mean here is these are claims that are being brought against the company itself, the company in liquidation or administration. They arise from something that happened before you got involved. It's a pre-appointment issue, pre-appointment claim. And they are claims that are not stayed by the insolvency proceedings themselves. And so what we're not covering, what does not count as zombie litigation, are claims that are brought against you as office holder yourself. That's a separate topic by itself, I think. And those claims, if they are legitimate, of course, are outside the statutory stay. Similarly, they're not claims that arise from something that's post-appointment. Those can be things like claims for directions or appeals against decisions that you have made. Those sorts of claims, if they are legitimate and brought against the bust company, they may rank as expenses of the liquidation. And zombie litigation, of course, is not claims that are stayed in the insolvency proceedings, which, of course, is most claims that are made against a company that goes into administration or liquidation. So legitimate claims against the office holder are not stayed. Legitimate claims for expenses are not necessarily stayed, and those are considered as claims within the insolvency proceedings. So let's move on to look at the insolvency stays that apply to litigation generally. Firstly, some basic principles. Why do formal insolvency procedures stay litigation? All sorts of good reasons. One is that the pari passu rule simply could not work unless you stayed proceedings, because if litigation were to continue, then that would give those creditors who are continuing with their claims an unfair advantage over those who are not doing so. Second one is that it allows you as liquidator to get on and do your job, because you're not having to fight fires and deal with court process all the time. You can focus on what's actually important in the administration of the liquidation or other procedure. And third thing is it actually maximizes realizations for all creditors, because it avoids wasting your time. It avoids the need for you and for creditors to appoint lawyers to continue to pursue claims on their behalf once the proceedings have started. The way that the insolvency stay works does, of course, differ from one procedure to another, but stepping back far enough and they all look pretty similar. So in bankruptcy, for example, the stay first comes into force with the bankruptcy petition, but it only really hardens when the bankruptcy order is made, and it is very broad in terms of what is stayed. Similarly, in a compulsory liquidation, there is an immediate stay that's put in place by the winding up petition, and that is hardened by the winding up order. In a voluntary liquidation, there is actually no automatic stay at any stage in the procedure. But if you need a stay, then you can apply to court for directions, and in circumstances where the court would not lift a stay in a compulsory liquidation, they are likely to impose a stay in a voluntary liquidation. So if you've got somebody who is threatening to bring proceedings in a voluntary liquidation, the counter threat to that is to apply for a direction under the Insolvency Act to stay the proceedings. Similarly, with administration, that's got possibly the most powerful moratorium of any of the procedures, and that comes into force from effectively the start of the appointment process, and again hardens on appointment of the administrator. And the administration stay can be lifted by agreement of the administrator, or by a court order. And the Atlantic Computers principles, which I will be talking about later, regulate the circumstances in which the court will lift the moratorium, and they also provide guidance as to when the administrator should lift the moratorium. And I think the principles that apply in Atlantic Computers are of more general application to all types of insolvency procedure where you're faced with a decision as to whether you should allow litigation against the company to continue or not, and if you are going to allow it to continue, on what terms. So let's look at the sorts of claim that is likely to break the litigation. And let's look at the reasons that solicitors might have for bringing a claim through the courts against an insolvent company. The first one is that they simply may not understand insolvency, and they may be determined to bash on regardless. That's actually unlikely to be the reason for them continuing. In my experience, most litigation solicitors who are not familiar with insolvencies are very, very cautious about getting involved in insolvencies, and very reluctant to do so. So chances are, if despite the insolvency the solicitor still seems intent on bringing the case, they may well have a good reason for doing so, and it's worth finding out what that reason is. Typical reasons would be that either they want possession of something for their client, it's an asset repossession claim of some sort, or they might want to enforce rights against a third party. And this is quite common in the situation where there's perhaps mis-selling claims of some sort. There's professional indemnity insurance in place, and they're looking to enforce their clients' claims against the bust company's insurers. And those claims are regulated by the Rights Against Insurers Act 2010. So let's look at that legislation. The general principles have been in place since the 1930 Act. That was replaced actually only about 5 years ago. So although the current legislation is dated 2010, it did actually take a few years before it was implemented. And the basic principle behind the legislation, both the previous Act and the current legislation, is that some insurance policies are in effect taken out of the insolvency. So I'll try and show you a diagram to show how this works. You can think of a liquidation as being a way of providing insulation in the form of the liquidator between the creditors and the assets. So the liquidator gathers in the assets, protects and preserves them. The creditors are not entitled to make claims against the assets directly to seize them, but the liquidator mediates the claims of creditors and distributes the assets to the creditors in accordance with their entitlement. Now, the assets can include all sorts of things. Typically, they might be debts due to the company, land, goodwill, intellectual property rights, contracts, and insurance policies. And some of the claims that the creditors are bringing might be contested claims, claims where liability is disputed and perhaps where quantum is also disputed. And those are the sorts of claims that would normally be covered by insurance one way or another. And without this legislation, the situation would be that those insurance policies and the compensation that the insurance companies are due to pay under them would themselves be assets in the liquidation that would be paid to the liquidator. And the result of that is that those creditors whose claims are closely linked to the insurance policies would not get as much as they think that they ought to be getting. They would expect to be fully compensated if the claim is covered by insurance. And the other creditors who have got no connection whatsoever with the issues for which the insurance is being paid out would receive a windfall and would get a larger dividend. So the purpose of the Act is to bring the benefit of those insurance policies outside the liquidation so that the insurance companies effectively pay the affected creditors directly, and that effectively cuts the benefit of those insurance out of the liquidation completely. The rights that creditors have got under the Act are triggered by most of the all of the common insolvency procedures. And I'm not going to go into detail about the changes between the old legislation and the new, but there are a couple of important points that are relevant. First of these is that under the 1930 Act, the third party, the person bringing the claim, had to establish liability against the insured, the company in liquidation, before they could make a claim against the bus company's insurer. So it was a two-stage process, and technically they had to get judgment against the company first, and only once they had got judgment could they then enforce the judgment against the insurer. It didn't always work like that, because very often insurers would step in at an early stage to defend the claim, because they saw it as not being in their interests for the creditor to get a default judgment and then to be trying to enforce that. They would rather the issue was properly litigated and liability properly established. Now, under the new legislation, the third party, the creditor, has got the choice of bringing a claim only against the company in liquidation's insurer. So they can choose not to name the company in liquidation at all in the proceedings that they are bringing. Now, I think that some solicitors who bring these sorts of claims haven't perhaps realized that that's now the case, or if they do, they may not know who the insurer is, or they may simply be taking the cautious lawyer's approach of suing everybody that they possibly can if there are people to sue. Another important policy that the legislation includes is it tries not to affect the rights of either party insured, whether it's the creditor bringing the claim or the insurer. It tries to make sure that, so far as possible, the fact that they're having to bring the claim under this legislation does not affect the result of it for either of them. This part is important. If you've got a pen and notepaper with you, you might want to just jot this down. Under the legislation, the third party does have a limited right to information. And this is in addition to the normal rights about information that they've got. And they've got the right to ask for that information from the insured itself, the company in liquidation, or they can ask for that information from anybody else who might have the information. And typically, those who might have that information might be the company's insurers, if they know who they are, the company's brokers, if the creditor knows who they are, the directors of the company in liquidation, who may or may not be cooperative and who may or may not actually have the information available to them at that time, or they can ask you as the office holder, the liquidator, for that information. And this is the information that they are entitled to and which you are bound by law to provide to them within 28 days. You have to tell them whether there is an insurance policy that seems to cover their claim. And if there is an insurance policy that seems to cover their claim, you have to tell them who the insurer is, in broad terms, what the terms of the policy is, whether the insurer has denied liability, whether the company in liquidation has itself had to sue the insurer, and if there is a cap on the cover available, how much of the total cover is still remaining. And if you can't answer those questions, you should say, I don't know, as the answer to them, and explain why you don't have that information. And if you get a request like that, I strongly suggest you don't ignore it. You do deal with it within the statutory 28 days. If you don't, the creditor might seek a court order from you to compel compliance. And if they have to apply to court to make you comply, they will probably get a costs order against you. What you can do with a request like this, and I would encourage you to do this, is pass the duty on to somebody better able to answer than you. I mean, if you can answer, great, but if you can't answer substantively, then refer the letter on immediately to the company's broker, their insurer, and the directors. Ask all of them to reply and tell the creditor that that's what you're doing. You may get a letter from the claimant's solicitor asking permission to lift the proceedings, as well as asking for information about the insurance. In terms of dealing with a request to allow the litigation to continue to lift the stay, this is where we need to look at Atlantic Computers and the principles in that. As I've said, as you know, Atlantic Computers is mostly about when leasing companies are entitled to repossess their goods, and it is very much about the administration moratorium. But it does set out some general principles about how an administrator should behave in balancing competing interests in those circumstances. And I think that's very useful in terms of looking at these sorts of claims in all types of insolvency procedure. So these are some of the Atlantic Computers principles that I think are relevant here. Firstly, the creditor, the person asking for permission to bring the claim, they have to make their case out. They have to present you with reasons why you should allow them to sue the company in liquidation or administration. The starting point should be that you ought to grant permission if it won't cause damage to the liquidation or the administration. And of course, some of the damage it may well cause is simply the cost of having to deal with it, which of itself in many cases would be a good reason for refusing permission. What you should be looking at is the purpose of the administration, how likely you are to achieve the purpose, and what stage you're at, whether it's early, in the appointment, or whether it's quite late. You'll be looking at balancing the interests if permission is granted, to see which party will be more damaged by the continuing litigation. In the case of Atlantic Computers, it suggested that administrators should mitigate the damage by paying rent for continued use of the assets. And conditions may apply if permission is granted or refused. So if you do allow the litigation to continue, you can impose conditions for doing that. If you refuse permission, you can say that you're refusing, but saying that although you are refusing, nevertheless you are going to do this, that, and the other to assist the creditor, short of allowing them to issue proceedings. And these are important principles. As administrators, and in fact in many other offices that you hold, you are officers of the court, so you have a duty to act judicially. That means you should be impartial, independent, you should give reasons for your decisions. You should be decisive and act quickly when you can, perhaps making an interim decision in cases where you can't yet make a final decision. You have to act responsibly. You're not supposed to use your powers to negotiate for partisan advantage, and you should give reasons for your decision. I'm now going to talk about the civil procedure rules, and these are the court rules that apply to High Court, County Court, and Appeal Courts. And CPR 31 in particular is all about disclosure, and disclosure is the legal duty that parties to litigation have to provide information to each other. And the person bringing the claim, the creditor bringing the claim against the company in liquidation, known as the applicant, of course, they are entitled to information from you as liquidator, and also separately and independently from the company, who are, of course, the named respondent to the litigation. The information they are entitled to from you is the information I've already told you about, the basic information about the insurance policy that covers their claim. The information that they are entitled to from the company in liquidation is much more comprehensive, and it's essentially information that's relevant as evidence to the claims being brought. So typically the company's operational files, perhaps board minutes, operational instructions, correspondence, all sorts of matters like that. And CPR 31 applies to disclosure of all of those documents and information. Now, I've found it useful to think about the situations that apply, and these are in the context of who actually has to pay for this particular exercise. But I found it useful to think about the circumstances as a quadrant in 4 parts, a cake, and you cut it vertically and horizontally. So the vertical cut is between pre-action disclosure, which is the disclosure of information before the company has been sued, as against post-action disclosure, which is information which is disclosed after proceedings have been opened and served. And there's the horizontal cut. Below the line is disclosure that is requested from a third party, somebody who is not being sued, which in this context means you, the liquidator. And above the line is disclosure from the respondent, the person who is being sued, which in these situations means the company in liquidation. And the normal disclosure that you get in litigation is post-action disclosure from the person being sued. And in those circumstances, the person being sued normally cooperates with the request for disclosure, and if they don't, and if an order is made against them to force them to disclose documents, then they would normally have to pay the applicant's legal costs of bringing that claim. Pre-action disclosure from the company in liquidation would be unusual. There may be circumstances when the creditor can reasonably ask for it, but in cases like that, because the company hasn't yet been sued, they would normally be expected to pay the company's costs of disclosure. And those would not only be the legal costs involved in negotiating and agreeing the disclosure, but they would also be the actual time costs that you and your team would incur in providing the information that's been requested. Similarly, if they are asking for disclosure from you as the liquidator, then and this might be asking you to do the work of disclosing information from the company's files in your possession, but that's a request for disclosure from you as a third party. They're not planning to sue you as liquidator, but they want you as liquidator to do the work of disclosing information from the company's files. And the normal rule there again is that the creditor would be expected to pay your legal costs and your professional costs of providing the information that's requested. Most unusual is where the creditor is looking for disclosure from somebody that they're not intending to sue before they've even issued proceedings. And again, same rule applies for costs on that the person making the request for disclosure would be expected to pay the costs of the third party. So that slide then summarizes that in a lot of these situations, because you as liquidator are a third party, if they're asking for you to do work to provide information from the company's records, you are quite reasonable in being asked to be paid time and expenses for doing that work for them. Now, there's a bit more to it than that, because it's not just sufficient for you to say, okay, this is what I'm going to charge you, what do you want? You have to remember the Atlantic Computers principles, and you have to be neutral in the litigation here, and you have to be open and you have to be fair. So remember, the other side are entitled to specific limited information about the insurance policy, which you should give to them quickly if you can. And if you can't easily, follow the Atlantic Computers principles, explain why you can't give it to them, and pass on the request to somebody who can deal with it. If they ask for information in terms of an evidence gathering exercise from you, or if they ask for more than they are entitled to from you, then you have to bear in mind that agreeing to provide that information may harm the interests of other parties, such as the insurance company. And again, you need to think about the Atlantic Computers principles there, but you ought to be able to agree for them to pay your costs in providing that. So if they seek information from the company and you can give that information to them, and you can do so without harming unduly other parties' interests, you can agree terms of disclosure. It's probably going to be third-party disclosure, which means they should be paying for your legal costs and your time in doing this. And it may be pre-action disclosure, which only strengthens your right to ask for your costs to be paid. You should expect demands with menaces. You are dealing with litigators after all, so the letters will all be dear sirs and threatening dreadful things for you, but you have got decent legal protection for your position in this. You will need to explain that, and you may need to explain it carefully and in some detail, because the litigators demanding disclosure may themselves be confused about the demarcation between you as liquidator and the company whose assets you are dealing with. And the consistent theme throughout what I've been talking about this morning is, do remember the Atlantic Computers principles. Be fair, be open, be careful, be neutral, and be reasonable. So a couple of minutes over the allotted time. I do apologize for that, and I do apologize for my voice failing on a couple of occasions during this. I've just been throwing off a cold over the last few days. But if you have any questions, I will be very happy to try and deal with them now if I can. And if not, I will see you in a month's time.